All right, we can go off the record. Here's the thing. Follow through on your probation. If you don't follow through on your probation, you're looking at potentially 10 years in the prison. Do you understand?
The state isn't focusing on prior history, because there isn't one. They're focusing on escalation. What started as a suspected DWI turned into crashes, resistance, and alleged assaults on officers. For prosecutors, escalation in a single night can outweigh a clean record.
All right, the court is calling 2025 CR 006868, State versus Gage Guerra. Can I have parties announced for the record?
And Johnny Cisneros for Mr. Guerra, and I have an intern, Your Honor, Ms. Irma Porras. She's a UTSA senior. She wants to go to law school, and she came to me, well, she was referred to me to mentor her, and this is her first time with me today. So,
Awesome. You have a good mentor.
thank you, Your Honor.
All right, so on this case, Mr. Cisneros had withdrawn and Attorney Robert Maurer was appointed. And so, counsel, are you asking to be placed back as the attorney of record on this case?
Yes, ma'am, that's fine.
All right, and Mr. Guerra, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Gage Ashton Gary.
All right, Mr. Guerra, you previously had a court-appointed attorney, and that attorney was appointed after Mr. Cisneros' motion to withdraw was granted. Are you asking that Mr. Cisneros, or I should say, do you have any objections to Mr. Cisneros representing you for this hearing? All right. Then the next thing, you entered a plea on December 5th, and according to your plea, punishment is to be assessed at a cap of 5 years in the prison. The state is opposed to your application. There's a $1,200 fine. They're taking in consideration 2025 CR 006870 and 2025 CR 006869. And there's to be restitution to the complainants in those two cause numbers and restitution to the complainant in this cause number. Have both parties had a chance to review the PSI and the TAP evaluation? Okay.
I have reviewed.
All right, any objections, defense?
No, ma'am.
State, do you have any objections? All right, state, you're opposed. Do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
No, ma'am, this argument.
All right, state, you're opposed. The court will hear your argument.
Yes, Judge, state is opposed simply based on the order of events that occurred that night. While Mr. Guerra has no prior criminal history, as a series of actions that went from bad to worse. He was suspected of DWI and escalated from there, resulting in physical altercation between him and assaulting 3 different officers. So because of the events, and although the injuries were relatively minor, it was still unnecessary. Because of that, I do believe that he's
All right, defense.
Judge, they arrested someone for being intoxicated. I'm okay with that. What I'm not okay with is that they're saying that he hit 3 officers, okay? 2 of them are, which are taken into consideration now, and of course, we're not objecting to that. But the fact that they're objecting to community supervision, when you look at the police report, Your Honor, it says that when they stopped him, he was not complying with their orders, and they had to tell him that if you don't get out, we're gonna drag you out. We're gonna take you out, to paraphrase, okay? But in the report, it also states that his legs were already out of the car when they started taking him out of the car, dragging him out of the car. And we all know that the policemen are not gonna grab someone and take them out of the car by their legs, because they wanna make sure they know where their arms are. Because they don't wanna have access, the officers wanna make sure that the person that's being arrested does not have access to a weapon where he can hurt or kill them. So for them to say that he was fighting them to get out of the car and not complying, and they're saying in the same statement that his legs were already out of the car, that means he's complying, and my client says he was complying. It just got out of hand, and the fact that he was intoxicated and the fact that they were mistreating him led to him being charged with assault. And I don't know that that's fair. But here we are, and all we're asking for, I mean, as the DA told you, Your Honor, he doesn't have a criminal history. He's a good young man. He drinks 2 beers a week or a day or something like that. That's not an alcoholic or anything like that. He doesn't take drugs or anything like that. He's never been in trouble. I got to know him. There were a few issues. I withdrew. I felt guilty for withdrawing, and I'm here to represent him because I'd like to represent good people, and he's a good person. And you know, we made up, and I'm here, and this is a pro bono case because I believe in him. He's a good person. He does not deserve to go to the penitentiary on something that he was complying with.
All right, any further response? How old are you?
25.
Why are you doing silly things? Because this is silly.
It was a mistake.
No, not a mistake. We make choices in our lives. So this doesn't qualify as a mistake. This qualifies as a choice. So how much had you drank that night?
2 beers, 3 beers.
Okay, this is what I've discovered in my career, and I think the state will tell you and your attorney will tell you. Whenever someone is charged with DWI or they get pulled over for suspected DWI, when the officer asks them how much they had to drink, you know what their answer always is? 2 beers. But what I can tell you, and if I'm wrong, let me know that I'm wrong. I will take no offense. 2 beers doesn't result in this all happening. So how much had you been drinking that night? Okay, and why don't you know?
I don't remember.
Okay. Do you have any children?
Um,
All right. Who's your support system?
my sister, my mother, my father.
All right.
And he has a place to go when he gets out. I believe he's gonna live with his grandmother, correct?
Yes, sir.
All right. And this is the only offense he has?
Other than
All right. Probation. I'm gonna give you a choice. Some people say probation in this court is very difficult, but I set conditions so that people can hopefully be successful. And I don't see them again, and the legal system doesn't see them again. Number one, we're gonna find out if there's any restitution owed. So this is gonna be recalled for a restitution hearing. And I'm gonna give the state 30 days. Ms. Ferguson, what's a 30-day reset for a restitution hearing? All right, so your restitution hearing is gonna be on March 5th, but I'm gonna give you a choice. There are no other choices. And either choice you decide to go with, you're gonna be in custody for a little bit. First, I can deny your motion and I'll sentence you to 2 years in the prison. Or I'll grant your application for deferred adjudication. You gotta remain in custody until there's an evaluation for felony drug court. If felony drug court doesn't accept you, you're gonna do some inpatient treatment, and I'm thinking inpatient treatment at SADC. Those are your only 2 choices.
May I speak to him for a second? Thank you.
Yes.
Right now, yes, ma'am.
Because we're gonna start a jury trial, so. All right, we're back on the record and 2025 CR 006868. State versus Gage Guerra. All right, Mr. Guerra, I gave you 2 choices. Which do you prefer?
I'm gonna take the program.
All right. So this is what the court will do. The court will sentence you to 6 years deferred adjudication. There's to be regular reporting by Zoom or in person. regular random UAs, proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. In custody, the following will occur. There's to be a referral to felony drug court. If not accepted, then you will remain in custody till transferred to SATF. There's to be 200 hours of community service restitution. How far did you go in school?
11th grade.
All right. Is there a reason why you didn't graduate? Do you have your GED? All right, why not?
Started stacking off.
All right, the court is going to request that you obtain your GED. And once that's obtained, there will be 50 hours of community service restitution that will be deemed satisfied. The remaining 150 hours of community service restitution will be deemed satisfied if you obtain some sort of trade school certification or if you are enrolled in some sort of higher learning. Now, here's the thing about that. I'm not going to order you to obtain your trade school certification or anything else. But if you do, 150 hours of community service restitution will be deemed satisfied. If you don't, you're going to end up probably picking up trash off the freeway in the heat of San Antonio. And regardless of how the weather is now, you know, it gets at least to 150 degrees. There's to be a $1,200 fine. That will be probated. Take in consideration 2025 CR 006870 and 2025 CR 006869. We're going to have a restitution hearing on March 5th, 2026. And there's to be restitution, if any, to the complainant in this case and to the complainants in the cases that were taken in consideration. Do you have any children? That's a good thing. Don't have any children until you have your life together. You understand? Probation, is there anything else?
No, Judge.
State anything else?
Yes, Judge. During the brief intermission, I did look at our notes and we have made attempts to contact the victims regarding restitution and I have not got back to us, but this time we would ask.
Norma, remove the date for the restitution hearing. The state is waiving restitution.
Thank you.
So probation, restitution is waived. And I'll let the record reflect that the state has made several attempts to obtain any restitution amount. All right, is there anything else that you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
I haven't signed that.
Yes.
I believe that was it said 5 years instead of 6.
No. This is a trial court certification. This lets you know whether or not you can appeal or complain about things that have happened with regards to your case. Do you remember signing that?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is it's not a felony conviction, so you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. Follow through on your probation. If you don't follow through on your probation, you're looking at potentially 10 years in the prison. Do you understand? All right. Make sure you stay in contact with probation. If you have an issue, you feel as though they're not addressing it, you can always come back to the court and address it with me, okay?
Thank you, Your Honor.
right, thank
You won't
you.
see me here again, promise.
All right, good luck to you.
Thank you, Your Honor.
Notice something important. Both options involve custody. That's the accountability piece. Even if she grants deferred adjudication, he's not walking out. The court is balancing punishment with rehabilitation, prison for certainty, or structured treatment with strict oversight.
Has anyone promised you anything other than the plea?
No, they have not, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am.
All right, if you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of attempted assault of a public servant. They're asking that your punishment be assessed at 288 days in the Bexar County Jail under 1244. They're taking in consideration 2025 CC 010513.
010515.
Ah, the writing is a little bit off. So they're taking in consideration, can't read the writing, 2025 CC 010515. Did you understand that to be the plea?
Yes, I did.
Defense,
That's correct, Your Honor.
state?
is, yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Did, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Did understand, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Plead not guilty. I mean, I'm sorry, guilty. Oh,
All right, are you sure about your plea?
absolutely sure, yes, ma'am.
All right, and you want to proceed with this plea bargain agreement and not proceed with the jury trial?
That's correct, Your Honor.
All right, the defendant has pled guilty. State, do you have any evidence to support the defendant's plea?
Judge, we obviously exhibit number 1, all attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find that there's sufficient evidence to find you guilty of the lesser included offense, and the court will find you guilty. Are you proceeding with sentencing?
We're ready, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Court will follow your agreement, sentence you to 288 days in the Bexar County Jail under 1244, give you credit for any time served. Take in consideration 2025 CC 010515. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, Your Honor, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, I do, Your Honor.
All right, we can go off the record. Here's the thing. I understand that maybe you were having a mental crisis at the jail, and that's why this occurred. So when you're released from custody, you need to make sure you go either to the Center for Healthcare Services. If you can't find a place, come back here. If I'm still here, I'll pick up the phone and get help for you, okay?
I understand, Your Honor.
All right, good luck to you, sir.
Yes, ma'am, and thank you.
All right, thank you.
Thank you.
And you have him dressed very appropriately.
Thought we were picking a jury today, Judge.
Thank you.
The judge follows the deal. 288 days, credit for time served. But listen to what comes next. She acknowledges a possible mental health crisis. That's significant. The sentence punishes the conduct, but the court is signaling that treatment, not just custody, is the long-term fix.